Continuing from our previous discussion on the Arizona Residential Landlord and Tenant Act, ARLTA, and its impact on residential leasing, it is equally critical for real estate professionals to understand the boundaries of the Act's application. Specifically, that ARLTA does not apply to commercial properties. This distinction is fundamental in property management, as it determines the rights, responsibilities, and legal remedies available to landlords and tenants depending on the nature of the property being leased. Arizona does not have a Landlord-Tenant Act that applies to commercial properties. The Arizona Residential Landlord and Tenant Act, found in ARS, Title 33, Chapter 10, governs only residential dwellings and expressly does not apply to commercial, retail, office, or industrial leases. Instead, commercial landlord-tenant relationships in Arizona are governed primarily by general contract law and the specific terms of the lease agreement, with limited application of other statutes such as the Statute of Frauds, ARS, Section 44-101, and applicable zoning, building, safety, and federal accessibility laws. As a result, the rights and remedies of commercial landlords and tenants, such as notice requirements, default provisions, and termination rights, are largely determined by the lease itself rather than by statute. The ARLTA, codified under ARS, Title 33, Chapter 10, explicitly applies to residential rental properties, those intended for human habitation, such as single-family homes, apartments, townhouses, and condominiums. The statute's purpose, as stated in ARS Section 33-1302, is to simplify, clarify, modernize, and revise the law governing the rental of dwelling units and the rights and obligations of landlords and tenants. By contrast, commercial properties, such as office spaces, retail centers, industrial warehouses, and medical facilities, fall outside the scope of ARLTA and are instead governed by
Arizona contract law and ARS, Section 33-361 through Section 33-381, which address leases of non-residential real estate such as rent upon crops grown.
The primary reason for this distinction is that commercial leases are considered business-to-business agreements entered into by sophisticated parties who are presumed to have equal bargaining power and the capacity to negotiate terms freely. Residential tenants, on the other hand, are viewed as consumers who require statutory protection due to unequal bargaining positions. As such, ARLTA includes provisions that cannot be waived by the tenant, such as those relating to habitability, security deposit limits, and landlord entry restrictions. These consumer protections do not exist in the commercial leasing context. For example, consider two leasing scenarios. In the first, a tenant rents a two-bedroom apartment in Mesa. The landlord must comply with ARLTA's habitability standards under ARS, Section 33-1324, maintain essential services, and return the security deposit within 14 business days after move-out under ARS, Section 33-1321D. In the second scenario, a small business owner leases a 1,500 square foot office in Gilbert. Here, the lease agreement itself governs all terms, such as repairs, maintenance, rent escalation, and termination rights, because ARLTA does not apply. If the roof leaks or the HVAC system fails, the tenant must refer to the lease to determine whether the landlord or tenant is responsible for the repair, rather than relying on statutory habitability protections. Another key difference between residential and commercial leases lies in eviction and enforcement procedures. While both types of leases use the forcible entry and detainer (FED) process under ARS, Section 33-361 SEC, and ARS, Section 33-1368, the procedural details differ. Under ARLTA, a residential tenant can be given a 5-day notice to pay or quit, and the landlord must maintain specific tenant rights during the process. In contrast, commercial landlords have broader authority to repossess premises under Arizona revised statutes, Section 33361A, if rent is unpaid or the lease is breached. They may also terminate the lease or sue for damages directly without the consumer-oriented restrictions that exist under ARLTA. Commercial leases also differ in how they handle security deposits, maintenance, and default remedies. For instance, there is no statutory cap on the amount of a commercial tenant's security deposit. Parties may negotiate any amount deemed appropriate. Maintenance responsibilities are often assigned to the tenant through triple net lease (NNN) agreements, meaning the tenant pays property taxes, insurance, and maintenance in addition to rent. Default clauses in commercial leases are also more complex, often allowing landlords to accelerate rent, apply interest penalties, or pursue liquidated damages. These terms are enforceable as long as they are consistent with Arizona contract law and not deemed unconscionable by the court. To illustrate, imagine a business leasing a warehouse in Glendale for storage and distribution purposes. If the tenant fails to pay rent, the landlord can terminate the lease under ARS. Paragraph 33-361A and recover possession immediately, without providing a 5-day notice to cure, unless the lease itself provides otherwise. Conversely, if the same tenant were leasing a residential apartment, the landlord would be bound by ARLTA's notice and waiting period requirements before initiating eviction. In Arizona, commercial leases are governed primarily by general contract law, relying on common law principles, and by the written lease agreement itself. As parties to a commercial lease have broad freedom to negotiate and define their rights and obligations. Unlike residential tenancies, only limited statutes apply, including ARS Section 44-101, subsection 6, which requires leases longer than 1 year to be in writing under the statute of frauds, and certain Title 33 provisions that affect real property generally, such as those relating to liens and conveyances, rather than landlord-tenant rights. The Uniform Commercial Code, Title 47, may also apply when the lease involves goods or fixtures, and commercial properties remain subject to local zoning, building, fire, ADA, and health codes, as well as federal and state anti-discrimination laws in limited mixed use or applicable circumstances. Foundation Development Corp.'s Avi Lohmann's Inquirs 163, Arizona 438, 1990, is a landmark Arizona Supreme Court case involving a commercial lease and the consequences of late rent payment. In the case, Lohmann's, a commercial tenant, paid rent late, and the landlord sought to terminate the lease and forfeit the tenant's interest based on a strict lease provision. The Arizona Supreme Court held that forfeiture of a commercial lease is not favored, and that a landlord may not automatically terminate a lease for a minor or technical breach, such as a brief or inadvertent late payment, unless the breach is material or the lease clearly makes time of the essence. The court emphasized that courts must consider equitable factors, including the tenant's history of performance, the length and reason for the delay, and any prejudice to the landlord. This case is frequently cited for the principle that Arizona courts will look beyond rigid lease language to prevent unjust forfeiture in commercial landlord-tenant disputes. Review summary. The Arizona Residential Landlord and Tenant Act applies exclusively to residential dwellings and does not govern commercial properties. Commercial leases operate under Arizona contract law and ARS Section 33361 ATSEQ, giving parties greater freedom to negotiate terms without statutory restrictions. Residential tenants are afforded statutory protections relating to habitability, security deposits, and privacy, while commercial tenants rely entirely on the negotiated lease terms. Property managers and brokers must therefore correctly distinguish between residential and commercial relationships to ensure they apply the appropriate legal framework. Discussion prompts. Why does the Arizona Residential Landlord and Tenant Act not apply to commercial leases? Answer: because commercial tenants are considered sophisticated parties, capable of negotiating their own terms under contract law, unlike residential tenants, who require statutory protection. What is one major difference between eviction procedures under ARLTA and commercial leases? Answer: under ARLTA, landlords must provide statutory notice and adhere to tenant protections, while commercial landlords can often act immediately as to what is written in the lease. What type of lease is common in commercial property management that transfers maintenance responsibilities to tenants? Answer: a triple net lease, NNN, where the tenant pays rent plus property taxes, insurance, and maintenance costs. Closing remarks. Understanding the limits of the Arizona Residential Landlord and Tenant Act is vital for every property manager and licensee. Misapplying residential regulations to commercial transactions can lead to contractual disputes and professional discipline. By recognizing that commercial leases are governed by contract law and the parties' negotiated terms, real estate professionals can ensure lawful management, uphold fiduciary duties, and protect their clients' business interests. This distinction underscores the importance of competency, precision, and legal understanding in Arizona property management.